Application because they can't take this matter any further.
No, but that's the thing, my lord. That is the thing. This is coming from Mr. Gininda. Who is Mr. Gininda within the context of DCS, Department of Correctional Services? Because it's just a police. He cannot prescribe to the DCS on what processes are they supposed to be following.
Yeah, fine. I'm offering to speak.
This is a further perpetuation of what I'm referring to as a lynching.
I'm offering to speak to the head of
Yes,
the
my lord.
inspectorate of all the prisons in South Africa.
Yes.
And then give him these facts. And I'm inviting him to come here. I don't know. He's in Cape Town. I know he stays in Cape Town. If it's possible, spare weekend. He must come here.
All in one way or another overlap. Chair, I want to know from the department how they can tell us specifically that the various figures on suicide, which is the highest number that they give here, are actually suicides. And which of those related also to the manner in which inmates have been treated or neglected. We know very well that suicide, under conditions such as that I've just described, can't simply be said that these prisoners have decided to take their lives. There may very well be many other conditions, including also the manner in which Correctional Services officials treat these inmates.
Minister, in the prisons here in South Africa, I think two things that caught me that I'm stuck with here today while going through that report, and one cannot be diplomatic about it, is when I heard the words, dragged on a blanket. Dragged on a blanket. When I heard the presenter saying that he was carried on a wheelchair with his head dangling and his feet probably sweeping the floor. That is inhumane, to say the least. These are the stories we read about during the time of apartheid. And I cannot believe in today's day and age we still hear of such heinous, horrendous, heartbreaking stories unfolding in our prisons. Minister, this is a direct, unfortunately, reflection on you. This is during your watch where this is happening. All of those officials implicated in this, all of them tried to cover up. Not one stood up ethically and spoke the truth. Reports were tampered, misleading information was given by not one person, by everyone in all of these cases. We have been highlighting time and time again, and I'm sitting here this morning and I'm listening to everyone, and I'm asking myself, you know what, previously we have given suggestions, we have made recommendations, and 6 months after us making those recommendations, we go back to those facilities and no one has taken the time or day to actually implement not a single recommendation. I speak to something as simple as, if you look at these suicide stats, drug overdose stats, the state should actually be charged for all of these murders, if you look at it. Because this is negligence from the state. Our prisons are meant to be drug-free zones. How did the drugs enter a prison that's meant to be a drug-free zone? Who do you blame? Who accounts for that death? It should be the state. When you look at the suicides, the high rate of suicides, if we should conduct, I want to know what percentage of those suicide-related deaths were autopsies performed. Because I can tell you one thing, you'll find that those people were probably hallucinating, and this was also as a result of mental health and drug-related deaths. You'll find that a great percentage. I'm asking, we speak about gang-related attacks in the prisons. It's not the first time force is being used, gang-related. I want to know, in South Africa, we have the Poker Act. National Commissioner, are you aware of the Poker Act? NC, are you aware of the Poker Act? Just a nod. Why are we not utilizing the Poker Act in our prisons to identify gangs? And I spoke about this the other day when we spoke about that system that was meant to be introduced in 2025, where we actually assess the inmate coming in and actually identifying, because gangs, prisons in this day and age, it's a university for gangs. Why are we not identifying when people belong to gangs in prison and actually charging them via the Poker Act? That is another tool that you should be using as part of your programs that you are introducing. All of those programs that you are introducing now, we spoke about it, and we actually had the presentation the other day by the lady when we were on our strat meeting, and we said we cannot even measure the effectiveness of any of these programs in our prisons. Why? Because there's no integrated system that actually can hold all of this information. So vandag gaan ons maar nou weer hier kom, and I'm going to leave this place thinking about a body that was dragged on a blanket and this wheelchair incident that just has me, I can't believe it. But we're going to come back here and we're going to conduct oversight again, Chairperson, and guess what? You see all those catches hanging out the windows. No one's going to make it their effort today to actually just send out a simple memorandum asking those officials actually just to take off everything off the windows, just to make sure that there's no cling wrap in any of those cells that contributes, because these are the real stories, to pushing up contrabands, just to make sure that there's no toilet papers there's so many little things that you can do in your centers to avoid these incidents. But we're gonna go back, and I'm not telling you a word of a lie. We're gonna find all of these things there that makes these places conducive for drug overdoses and conducive for suicides. Minister, all of these things, I want to leave you with this, happened during your time, on your watch. Thank you.
We thank of Correctional Services for the macro and the micro reports that they presented to us. Both those reports are deeply disturbing. Chair, it doesn't help to put on slide 9 of the macro report the issues around apartheid-era prisons and the harsh conditions that prevailed in those prisons. It sounds to me as if the department is trying to tell us that things have significantly improved since then. Unfortunately, they haven't, although they should have improved significantly. Because today we have a constitution driven by a set of human rights values. But when I look at both these two, as I've said, disturbing reports, I do not see them being driven by the human rights values that are set out by our Constitution. Chair, we have become a society tolerant of what is unacceptable. I can tell you that in many other countries throughout the world, if reports like this were presented, it would have led to a national outrage. There would have been calls for the senior officials, including also the political responsible executive, the minister deputy minister to resign. Unfortunately, in our society, we've become far too tolerant of these kind of situations. Chair, if we look at the figure of the increase of unnatural deaths in prison, it is 30%. This is not improving, it is getting worse. Now I understand that there's the issue of the increase in terms of overcrowding, because as the report points out to us, more prisoners come in than those that go out. And of course, at the essence of the dreadful experience that prison in South Africa is the issue of overcrowding. Every one of us, as members of this committee, who go on oversight visits, can see that. But what we can also see is that the figures as they are presented to us, the breakdown in terms of unnatural deaths, suicides, overdoses, etc., all in one way or another overlap. Chair, I want to know from the department how they can tell us specifically that the various figures on suicide, which is the highest number that they give here, are actually suicides. And which of those related also to the manner in which inmates have been treated or neglected. We know very well that suicide, under conditions such as that I've just described, can't simply be said that these prisoners have decided to take their lives. There may very well be many other conditions, including also the manner in which Correctional Services officials treat these inmates.
The other maximum security center that may be convenient. 2, the second applicant's application is struck from the roll for lack of urgency. 3, the costs of Part A of the application are reserved for determination in Part B. I am down the judgment.
My Lord, this is something that has got nothing to do with the proceedings per se, but it has a bearing on the proceedings themselves. This relates to the condition in which Mr. Ncube is held at Kochimampuru prison. I must be very that it is bugging me to an extent that I'm no longer able to concentrate on the business of the day, which is to conduct this trial, because this is a collateral issue. It being collateral, however, as I'm saying, there's got a direct bearing on this case itself. The court will recall that in May, Mr. Ncube, through me, of course, informed the court that he's being held in solitary confinement, and the court made an order that the prison authorities should come and explain themselves out here. And before court, Mr. Koza came, accompanied by a certain Mr. Prebengo, and there was also a legal advisor who now I've forgotten her surname. And they made an undertaking. In fact, Mr. Koza then indicated that he was not aware of the incarceration circumstances of Mr. Ncube, but now that he was made aware, he will go and investigate what is happening, and then he will come and report. Because Mr. Ncube was complaining about the fact that he has been held in solitary confinement since his arrival at Kochimampuru in 2020. And he has not been informed of a reason why he has been held in solitary confinement for 4 years. He's telling me that the procedure that he has been informed of by the prison authorities for a person to be held in solitary confinement is when the person has been sentenced and is serving sentence, re-offense in custody. As a penal provision, they might then decide to take him to a solitary confinement. But this has not been the case with him. And even so, when a person has been held, has been sentenced internally, as an internal measure, a punitive measure, to go and spend some time in solitary confinement, the maximum period that such a person can spend in solitary confinement is up to 18 months. It's up to 18 months, my lord. Then the law says he should be released. But with him, he has been in solitary confinement since 2020 when he arrived at Kochimampuru prison, which is almost 4 years now. He has been consistently trying to siphon reasons, to get reason from the prison authorities about this continued indefinite detention in solitary confinement to no success. Fast forward, Mr. Koza came here, and then he made an undertaking that he would go and investigate the circumstances relating to him being held in solitary confinement, and he will report back. He hasn't. I took it upon myself, my lord, to take the matter up with JICS, which is the Judicial Inspectorate for Correctional Services. I wrote the representation on behalf of Mr. Mube and alerted them to the plight that Mr. Mube has been subjected to. They sent out a certain gentleman by the name of Mr. Maswanganyi to go and investigate the issue. However, in the course of investigation, it is procedural that they need to get a report from prison authorities. According to Mr. Mube, Mr. Maswanganyi had an interaction with Mr. Kebengu, the gentleman who accompanied Mr. Koza here. According to Mr. Mube, the report that he gets from Mr. Maswanganyi, because Mr. Maswanganyi firstly consulted with Mr. Mube to get the background of his complaint, and then Mr. Maswanganyi then approached Mr. Kebengu. But Mr. Maswanganyi, when he brought back the report to Mr. Mube, he told him that Mr. Kebengu is avoiding him and he does not want to talk about the circumstances and condition of his incarceration at Hoshimampuru prison. They are therefore unable to process his representation. Now we are at a position, in fact, in early August, I think Mr. Baloyi sent me a WhatsApp that came from Mr. Kiminda, trying to explain the circumstances of what could be happening. I'm not so sure whether I need to read on record, but part of what he's saying, he says there were some issues of security concerns around Mr. Mube, and it was at the same time accused number 2 had requested to be accompanied to a bank and stuff like that. So he's saying he does not know what is it that they are planning. Well, whether that is the case or what, it is neither here nor there, because all that I know is that Mr. Mube is serving a sentence at Hoshimampuru prison, and he's under the custody, he's under the guardianship of the prison authorities. I cannot fathom any reason why should Kininda, being a member of the South African Police Services, which is SAPS, would then have to go and interfere with the procedural processes and protocols of how inmates should be kept at correctional services. But fast forward, my lord, we are now at a position where I find it very difficult to get instructions from Mr. Mube. It has been almost 4 years that he's been held in solitary confinement. The system is systematically lynching him. This is a lynch. Each time he's supposed to get an answer of the reason why he's been held in such a solitary confinement for such a long time, they're backing and biting. That is a stealing that approach. They know that Mr. Mube has got no money. He cannot afford to fight his legal battles elsewhere. He cannot afford to have an attorney to bring up a substantive application to challenge this gruesome conduct by members of the correctional services. They know very well that he does not have them, and they are exploiting that very same situation. And the only recourse that Mr. Mube has, it is this court. If this court is serious about upholding the rule of law, I'm going to urge this court to get into the dynamics and find out what is actually happening with Mr. Mube. Because at the end of it all, this has got negative effect on what is termed a fair trial on Mr. Mube. Now, I know the court that is going to tell me that no, but I cannot interfere, and that will not be true. Because Section 173 of the Constitution reads as follows, and I'm going to read it to the court. Section 173, my lord, of the Constitution says, the bold letters there, or the topic is inherent power. The Constitutional Court, the Supreme Court of Appeal, and the High Court of South Africa, each has the inherent power to protect and regulate their own processes and to develop the common law, taking into account the interest of justice. Now, the question that we basically need to ask ourselves is it really in the interest of justice, where a person is facing such a massive trial, with such massive allegations against him, to be further subjected to this kind of a lynching? It surely can't be in the interest of justice, because they know that being held in a solitary confinement has got a damaging effect on your psychology. It psychologically defeats you, it psychologically drains you, it psychologically renders you vulnerable. At the end of it all, you're supposed to follow the trial, what is happening, you're supposed to formulate your defenses. In the circumstances in which Mr. Mube is being held, my lord, it does not have that advantage, because they are psychologically draining him. This is a systematic lynching on the psychology that Mr. Mube should be applying in the defense of his case. And that also affects me, my lord, because each time I consult with him, he brings up this, he brings it up to me. So I have to fight two fronts. Number one, I have to concentrate on this trial, on the merit of this case. And number two, I have to try and sort out what is supposed to be attended to by members of the Correctional Services, madam. I am therefore going to implore this court, and very sincerely, that the court should once again consider to call those members who were here in June to come and explain themselves out. Failure which, my lord, I will be left with no option. But that as we resume, because today is the last day, as we resume on the next semester, I'm going to take a week or two from the court's time to try and attend to Mr. Mnube's plight. Because in bringing a substantive application, I have to go and get an attorney who will be prepared to do this matter on behalf of Mr. Mnube pro bono. I have to go and sit in the office and draft papers on an agent basis to challenge the decision or to challenge the DCS, to give us the, in fact, to bring an application to compel them to give their decision. Then thereafter, having received their decision or their reasons why they're constantly holding him in custody, in solitary confinement, and then to bring an agent application in that regard. I will not be able, my lord. I need to be very sincere. I will not be able to do that while at the same time I have to proceed with this case. Otherwise, something must be done and be done very urgently. But as I've said, this court has got an inherent power to investigate. Not really to say this is what DCS should do, but at least to get to the bottom of this.
Okay.
Thank you, madam.
We confirm what Advocate Nisi has said insofar as what he has communicated regarding the involvement of Brigadier Gininda. Brigadier Gininda did take the matter up with Mr. Tebengu, the head of prison. That was in early August, my lord, and Brigadier Gininda then sent the following message on the 12th of August. This is the message that Advocate Nisi has referred to, and we'll just briefly put it on record. He said, he spoke to Mr. Tebengu, the head of CMEX prison. He maintains that there are security issues around accused number 3. He says his application was disapproved due to such security issues, but Advocate Nisi says they haven't received feedback on the application that was relaunched, but this is what Brigadier Gininda could establish that...
Where is the copy of the letter?
Yes.
Stating such refusal, if any?
Yes. We haven't been...
We don't have it.
Yeah, we were not finished with the letter. And he mentions in this message that Mr. Tebengu says he cannot take the matter further than that.
Is it?
Because of these security issues. And this is where the matter is, my lord. And in the message, Brigadier Gininda indicates that the only way of addressing the issue is if Advocate Nisi brings a separate application in another court so that all these issues can be ventilated. Advocate Nisi did, in his address this morning, point to the fact that accused number 3 is impecunious and that he will not be in the position to fund such an application. We are therefore, my lord, at a dead end. Our suggestion would be once again that Mr. Tebengu will be summoned to court to come and explain these issues himself, and we can then take it from there, my lord. As far as Section 173 is concerned, we don't think of the Constitution. We don't think that it's applicable here. It merely refers to the development of common law, and that the issues that have been raised don't really fall under Section 173 of the Constitution.
The parties to this, but the state is wrong in saying that Section 173 is not applicable. Section 173 says about the court regulating its own processes. It does not only speak about the common law. But nonetheless, I think what the court is suggesting under the circumstances, even if Judge Cameron, the Honorable Judge Cameron himself is unable to come here, I think they work as a group there. They might delegate maybe somebody very neutral to come and attend to this issue. Probably to then have to come to.
No, but fellows told me that the other guys say they don't want to be involved. You must bring an application because they can't take this matter any further.
No, but that's the thing, my lord. That is the thing. This is coming from Mr. Gininda.
Huh?
Who is Mr. Gininda within the context of DCS, Department of Correctional Services? Because it's just the police. He cannot prescribe to the DCS on what processes are they supposed to be following.
Yeah, fine. I'm offering to speak.
This is a further perpetuation of what I'm referring to as a lynching.
I'm offering to speak to the head of
Yes,
the
my lord.
inspectorate of all the prisons in South Africa.
Yes.
And then give him these facts. And I'm inviting him to come here. I don't know. He's in Cape Town. I know he stays in Cape Town. If it's possible, spare weekend. He must come here.
Family, we're back again. This is the Family Channel. We are back again. We are going to talk about the portfolio committee that was taking on the corruption that is going on in the correctional services, the cover-up. Before I go any further, I just want to say this few things. Because we have seen in the Meyiwa case, Senzo Meyiwa case, where we have seen Mube, which is accused number 3, who has been kept in solitary confinement. Because normally solitary confinement in prison, they only keep people who disrespect or they are correcting them on something. But for Mube, since he came in that prison, attending this case of Senzo Meyiwa, he has been dragged into the solitary confinement for no reason. Because nobody could explain to him as to why, even when the lawyers of Mube, which is accused number 3, were asking the prison authorities as if, why is it that Mube is in solitary confinement? But they could not get answers. So, as much as Advocate Mnisi has explained here, they end up getting a lawyer who had to attend to the issue of Mube being kept in the solitary confinement for 4 years. That is a discipline through Gininda, because when they want to smear you or they want to destroy your mind, your thinking capacity, your rights, your dignity, and the torture that comes with solitary confinement and all the stress that comes with all that, you are kept in solitary confinement, you don't mix with other people, all the tension that comes to Mnube's mind, that came into Mnube's mind, were so severe that he could not concentrate in his case, a case that he's been accused of. But what surprises a lot, that I think the prison authorities, if they see this video, they should try to find out why Brigadier Gininda, who is a police officer from the SAPS, is involved too much into prison because of accused number 3. They have to investigate this, because Gininda has got a hand allegedly about this accused number 3, because everything that has been happening, because it is believed he is the one who shot Senzo Meyiwa. So they are trying to do this kind of torture because he is refusing that he was part of this. The case of this Senzo Meyiwa and the accused that are there, we have a strong belief, allegedly, that these are not the right culprits that are being brought in front of court. That's why the torture of accused number 3 is so severe, because he is if they happen to get a convict, if he happens to be convicted on this crime, we are not saying he is not a criminal, let me say it like that. As much as he has been found in other cases, not this one of Senzo Meyiwa, why then the Senzo Meyiwa case is too much pressed on him? It was believed that he had a gold tooth. The DNA, it's excluding all these accused that are in the dock. So we have a serious problem as to why, more especially accused number 3, is so pressed or is so tortured to be kept in solitary confinement. And when the lawyer of accused number 3 tried to address the issue in court to the judge, and the prosecutor came up with a WhatsApp that was sent by Brigadier Gininda. How is Brigadier Gininda attached to the prison cell? That is where the corruption is. I just feel this investigation can be taken by Mkwanazi, because there's something that is smelling. There's a can of worms that is smelling there that needs to be addressed. So what I'm saying here is, for him to be out of solitary confinement, it was through a lawyer that was organized by his lawyer, which is Advocate Mnisi, organized another white lady who came and made an application, because Mnisi has been talking, the Advocate Mnisi has been talking about this, but nobody could listen to him. So he was also stressed out, because when he has to get some kind of direction as to how to go about with the case from his client, it was hard, because his client was not concentrating on the case because of the solitary confinement that he was kept for 4 years. 4 years in solitary confinement, something that is never heard of. And who was behind that? Everybody has been hiding and trying to cover up. When you ask this one was covering up, like Niehaus has said in this, and the lady who were in the portfolio committee, that there's a lot. There's people, they end up committing suicide in prison because of the torture they get from the authorities right in prison. So it's not like this suicide that comes from the prisoners there. It comes from nowhere. Carl Niehaus explained this thing in a way that even a lay person could understand, as to thus people, they get into this kind of killing themselves because of the torture that they are getting from the prison authorities. Mube is one of those people who has been kept in solitary confinement. If the minister sees this video, he should take on this. Or if any of the EFF or one of this portfolio committee, they should address this issue and try to find out and make a follow-up. Because at least this guy, Mube, accused number 3, he is still alive. He can easily explain to the committee as to exactly what is happening in prison, so they can get the gist of exactly what is happening in that prison and how Brigadier Kininda is involved in prison when he is not working in the prison, but he has a say in the prison. It means he's got a connection with certain corrupt individuals from the prison to do the torture to this accused. So that is the problem, because you cannot be kept in a solitary confinement for full 4 years in solitary confinement. It's against the law. That is called torture, because you're taking the dignity from this man. You're taking his rights. All the rights that are explained in Section 35, they are all taken by what these authorities in that prison are doing to the accused. So I wish anybody who comes across this video from maybe the portfolio or wherever, they can address this issue of Mube, because he is not the only one. A lot of can of worms can come out, so that we know when we talk about correctional services, we're talking about a place whereby when you have done wrong, you are arrested and you are charged. Once you are charged, you go to prison. After prison, because prison is a correctional services, so that they correct the mistakes from whoever individual, so that when he comes back to the community, he can live with the community in peace. So note this application that the authorities are applying, hardening these people's hearts and mind, and people end up killing themselves there. So what do you think, family, about this? Please drop a comment. Don't forget to like, share, and subscribe. And tell the love. This is the thing that our people are going through. We know everybody makes a mistake in whatever life. Some people have never tasted prison, but they have made some mistakes. So it doesn't mean if you have never tasted prison, you'll never. Maybe one of your family or whoever will go through this. This is things that we have to take on and talk about them, so that whenever our relatives or whoever gets into such problems, they will go there and be taught how to live with people, not to get people who are going to harden you again and come out from there with nothing. Why do we call it correctional services when people are going to come there and still come back being animals amongst our communities? So family, drop your comment. Don't forget to like, share, and subscribe. And turn on over to the love. It's going to be bravo, bravo, bravo.